atmosphere.
In any heavy litigation, there are moments of disagreement between the teams, but I'm sure everyone in court will want to join with me in offering our warmest congratulations to the future Lord Snowden.
You're very well informed.
It's already 90 minutes old. Good news. Good news travels fast. Congratulations, my lord. Any people at the bar will be happy with the news. Now coming back to less happy matters and the unfortunate events of this case, and Mr. Manduka having set up this partnership, watching it come to fruition, but sadly from the sidelines, because as you've seen, in the second half of 2021 and the start of 2022, there were at least 63 million sales of LFTs, and the average rate was £1.50. So we are talking about £100 million worth of revenue that was obtained from the arrangements that Mr. Manduka and Mr. Hughes had set up, and that, as the judge found, had achieved success and been translated into what he calls a functioning, viable trading operation. Then Mr. Manduka has seen all of that benefit go to Mr. Hughes, and Mr. Hughes's position is I'm not accountable for any of it. Not accountable for any of it. And obviously we rely, and the judge found that we are entitled to claim under Section 29. The position, as we see it, the general concept of how fiduciary duties operate and the duty to account arising even after termination of the fiduciary relationship, as described by Lord Briggs in the parts of Recovery Partners that I took you to before the break, support that interpretation of Section 29. Before we leave Rukadze, Recovery Partners, I'm using the two names interchangeably, we could just look at what Lord Leggett said. So Lord Leggett partly dissented on the general, which we're not concerned with today, on the general proposition about the counterfactual test. He didn't completely dissent because he held that, in brief, that there ought to be some form of counterfactual test, but it would not include the hypothetical consent of the principal, which was the argument that the defaulting fiduciaries had made, that you, the principal, would have consented to us doing what we did anyway, and so you haven't suffered loss or much less loss. Slightly curious counterfactual, but anyway, the majority, and this is now the law, simply reject that whole approach in toto. Lord Leggett, who delivered quite a lengthy judgment concurring in the result, partly dissented on that particular issue of principle, although he said that hypothetical consent ought to be irrelevant anyway. He was in favour of some assimilation to some extent with cases like Target and Redfern, where equitable compensation had the common law counterfactual approach brought in. What Lord Leggett did not dissent on, in my respectful submission, was the general approach to fiduciary duties. I'm not going to take too long on it because we're obviously dealing with Section 29, and so the relevance of Recovery Partners is to set the general context. But one sees that Lord Leggett at page 1800, for example, in paragraph 94 of his judgment, well, at the top of the page, he refers to the characterization adopted by counsel for the defendants. The essence of the profit rule is that the fiduciary acts in breach of the fiduciary duty where he makes a profit. He says he thinks that misrepresents the essence of the rule. This is 94. The very label profit rule is something of a misnomer. It treats a consequence in some cases of a breach of fiduciary duty as if it were itself a breach. There's nothing wrong in making a profit. To do so is not in itself a wrongful act. Indeed, it may not involve any act at all, as far as simply consists in receiving money. If, however, the profit results from conduct which is a breach of fiduciary duty, the fiduciary may be required to pay over the profit to the principal, i.e. to account. So that's the way in which he looks at it. He also talks about property at pages 1802 to 1803. And I draw your attention to that, not because I'm suggesting that what he says in what was in any event just his own decisive, but as with anything that Lord Legate writes, it's worthy of close consideration. And at paragraph 101, different views, this is in Boardman and Phipps, were expressed about whether knowledge or information can properly be described as property. It's quite a well-known debate, I think, that. And Lord Cohen accepted that information is not property in the strict sense of the word. Lord Hodson dissented from the view that information is of its nature something which is not properly to be described as property, double negative, in other words, he thought it was property, observing it may be very valuable as an asset. And one notes the next phrase, information acquired by Boardman, the trustee, was capable of being and was turned to account, and other dicta, which I won't go through. Lord Legate at para 102 says that he thought the law lords were mostly, as he puts it, talking past one another. There is no, I'm sure that won't happen in the future, my lord. There is no single or universal concept of property. The term property can have different meanings depending on the context and the rights in view. Thus, to ask, for example, whether so-called intellectual property is really property is to ask a meaningless question. What matters is not the label, but the nature of the rights. When rights are described as property rights, sometimes intended to signify that they are rights against the whole world, and that they automatically attach to whoever is the owner of the object or item in question. If the term property is used in this sense, plainly information cannot be property, and that's what he takes to be meant when Boardman, with those who said information is not property in a strict sense or in a normal sense, but a central and for some purposes defining feature of property is the right of the owner to determine how an object is used as between that person and one or more others. Information can be the object of such a right. Information can properly be regarded as property or treated as analogous to property in deciding how the law should protect that right. And then he goes on to apply that in, whereas between a principal P and a fiduciary agent A, P has the exclusive right to use and control the use of information. A, without the consent of P, uses the information for A's own benefit. The law provides similar protection to that afforded when tangible property is used without the owner's consent, etc. 105, context of a fiduciary relation of information about a relevant business opportunity is treated as property in the same sense. So all of that bears on the discussion that we've been having over the last day or so. And interestingly, 107 on the next page, and I'm not, everything in between is worth reading, but in the interest of time and my throat, I'm not going to read it out.
It is only, it isn't the majority
No, it's not.
judgment.
Of course not. No, and I did say I'm not suggesting this is in any sense decisive, but it is an important recent analysis. And 107, reasoning based on treating information about a business opportunity acquired by a fiduciary as a form of property sense seems first to be employed in cases involving partnerships. And then he cites two of the cases in your bundle, Dean and the Ours case, talking about information. And then he refers to company directors and so on. So one can see that the concept of property there is capable of being given a meaning of controlling the use of something as between yourself and one or more others. And that right of control can then find expression in a duty to account if the employee, if that's a word, misuses their position. And then just very quickly before we pass on, 1808, page 1808. Having analysed the relationship of the different facets of the rule, the two key fiduciary rules, Lord Legate says at 1, 2, 3, once it's recognised that the duty not to exploit property, information, or opportunities is distinct from the duty to avoid conflicts of interest. There's no difficulty why the former duty, explaining why the former duty continues after the fiduciary has stopped acting as such. And then he refers to company directors exploiting information opportunities of which they became aware while they were directors. He says, if the duty not to exploit any property information, this is 124, opportunity really were, as the Companies Act assumes, an application of the duty to avoid conflicts of interest, the survival of the duty after the person has left office would be indefensible, because the duty to avoid conflicts of interest only exists while the person is acting in a fiduciary role. But 125, it doesn't follow that after leaving office, a former fiduciary is free to use for her own purposes property belonging to the principal. Plainly she is not. The same applies to information and opportunities which are treated for these purposes as or as akin to property of the principal. The duty not to exploit such information opportunities does not depend on whether the individual continues to act for the principal. Next paragraph, he says the continuation is essential to its operation because of essentially the prophylactic factor, the need to deter it. He says judges have struggled at 127 because they suppose it's an instance of or based on the duty to avoid conflicts of interest. And then he reviews the cases, familiar cases to this court, I know. Going forward to 1811, paragraph 136. In this case, Mrs. Justice Cockrell thought it necessary to determine whether the defendants had taken preparatory steps before they resigned. She found that they did, but that finding wasn't essential to her decision. Although in general fiduciary duties cease when the relationship which gave rise to those duties terminates, e.g. through resignation, that is not true of the duty not to exploit any property, information or opportunity of the principal. So in the partnership context, it's slightly more complicated, but there is a shift in the fiduciary duties, but it doesn't extend to the duty not to exploit any property or information or opportunity of the partnership, because Section 29 accurately reflects that continuation by providing for the duty account in what it does, in the terms in which it does. And it says the duty continues after the relationship which gave rise to it has ended. Again, the partnership relationship doesn't end, it shifts, but it doesn't end. But even where it does end in the company case, the duty continues. Exploiting such information for the benefit of the individual's new enterprise is thus a breach of fiduciary duty, irrespective of whether there was some earlier breach before the individual left office with which it is causally connected. In the present case, the subsequent conduct of the defendants was the crux of their wrongdoing and a sufficient basis on which to hold them liable. And then subheading, obiter, what counts as an opportunity of the principal? There are important questions which this court may at some stage need to address about what counts as an opportunity of the principal which the fiduciary has a duty not to exploit. And then he goes on to discuss that. That's in the company law context, judge-made rules. In the partnership context, we have Section 29. So Section 29 answers that question, what counts as an opportunity of the principal, what counts as a resource. So that's what I'm going to look at in Ricazzi. I'm going to put that away now, please. Very briefly, Ms. Hilliard took you to and referred to the company law test, and the gist of the submission that she made was to reverse engineer into Section 29 the company law test, and quite on a number of occasions she made the submission to you, well, why should a partner be in a different position from a company director? An understandable point to raise, but we say that there are in fact some very good answers to it. The first one obviously is that the position for partners is what the legislation says, and it is not, with respect, a valid exercise of statutory construction to compare different legal regimes with the one that we're examining and then use the comparison to rewrite the statute. I mean, Lord Herschel in the Vagliano brothers said you shouldn't even look at the past law. It's not an appropriate exercise to do that. One can imagine what he would have said about that approach. And no authority has been cited to you on statutory construction to show that that is an approach that the courts should take in any field. But in any case, we say the comparative exercise the analogy that's drawn suffers from at least 4 defects. Defect number 1, a partnership is mutual. And it's pretty fundamental. As I think I said earlier, you don't know if you're going to be a giver or a taker under Section 29. And that's obviously not the case for a company where it's a one-way relationship. Secondly, the fiduciary relationship or the fiduciary role, as the Supreme Court put it, ends when a director leaves the company, as we just saw. But it does not end when a partnership is dissolved. It continues in a modified form until winding up the so-called twilight period. Thirdly, company directors can perfectly properly be subjected to restraints on any dealings with the company's business connections by express terms in their contract. And it is very common for there to be post-termination restrictive covenants, and one could see Section 29 as the legislative enactment of a form of express covenant against the backdrop of mutuality. And I mention that because Ms. Hilliard relied on the summary of Mr. Livesey QC in a case called Hunter Kane, which has been mentioned in some subsequent decisions, such as Foster Bryant in this court, of the need for company directors to be free under the general law to ply their trade, as it were, after the end of the directorship. But in fact, Mr. Livesey was very careful to say, subject to the terms of the contract. So what you're dealing with there is a default rule as to what the common law should allow, judge-made law, in terms of where you draw the line without an express agreement. But as I've said, and as Mr. Livesey's formulation expressly recognised, it's very common for there to be additions, and it's not far-fetched, my submission, to regard, even if one were to accept that the analogy is good, which for the reasons given, it wouldn't be a right premise, it's nonetheless not unreasonable to regard Section 29 as Parliament declaring a particular position for partners. And just as a fortiori, if private parties are free to agree a restraint that goes beyond the default rules set by judge-made law, it must obviously be open to Parliament to do that. And in short, the appellant submissions confuse the default position with what is permissible. And finally, the reason that the comparative exercise isn't appropriate is because the scope of or definition of what counts as the trigger for post-termination accountability of a fiduciary is not universal across different classes of fiduciary. Indeed, the very word post-termination, as I've already indicated, is not entirely apt for a partner anyway. And even in company law, as we just saw from Lord Legate's analysis, what may count as a triggering opportunity, the label maturing business opportunity being the conventional terminology, is highly fact sensitive, as Lord Briggs noted, and may be open to review, as Lord Legate noted. So one isn't to further review, which is what Lord Legate says in paragraph 137 of his judgment. So it's not as if one is looking at some sort of established touchstone which isn't going to be altered. It is a developing field, it's very fact sensitive, etc., etc. And whether the boundaries of a maturing business opportunity, e.g. in the somewhat precise form that Mrs. Justice Cockrell, as she was, accepted in the Recovery Partners case, in which our judge applied in paragraph 401, little 1 of his judgment, whether those are in fact boundaries that can be applied, or how far they should be applied, in what context, etc., can't be regarded as a settled question, even though it is possible to say that if you meet that definition, then you have hit the target. But whether that's an exhaustive statement of the target is very much an open question, I'd suggest, even in company law. But company law is not, in fact, a safe guide to interpreting Section 29. Now, the post-dissolution aspect was governed at trial, and in my respectful submission must be governed today by common ground between the parties as to the scope of Section 29. and that is at page 132 of the bundle. Paragraph 242, and it is not open to the appellants to in any way go behind this. The following matters relating to the construction and application of Section 29 are common ground between the parties. One, the proviso in Section 29.2, namely that 29.1 applies after the death, partner is not operative only in situations where a partnership is dissolved because a partner dies. The obligation to account imposed by subsection 1 continues to apply in what was described at trial as the twilight period, starting with the dissolution and ends with the affairs of the partnership being completely wound up. The parties agreed that Lindy and Banks correctly states the law in these terms. Although 29.2 only refers to the death of the partner, it's clear that the obligation under 29.1 will apply irrespective of the cause of the dissolution. So that was common ground, and that's as far in a sense as it needs to take.
I don't think that means that it applies in quite the same way. But
I'm sorry?
That doesn't mean it applies in quite the same way. I mean, we've seen with names that it doesn't apply in quite the same way, perhaps. But anyway, don't worry.
No, well, I'm not. In fact, I'm just going to show you, without suggesting that any of this is up for grabs in any way, but just Don King, which we looked at on day 1, I think, which is in tab 29 of the authorities. So, 2, I guess, for you. Page 497 of the bundle, paragraph 40 of Lord Justice Morritt's judgment. He agrees with the statement of principle of Sir John Pennycook, the Vice-Chancellor, in a case called Thompson's Trustee and Bankruptcy and Heaton.
Yes, this is, you mentioned this yesterday, just to say this is not expressly in the context of Section 29.
No, that's the, it is one of the unexplained mysteries why Section 29 wasn't mentioned. But
I think you referred to this paragraph yesterday.
I did. Sorry, then in that case, I don't think I took you to it, but I may.
I went and looked it up.
Oh, I'm very grateful, my lady. Well, then my lady at least is ahead of me. So
I haven't been so efficient, so you better keep going, Mr. Bear.
It's in the middle of that citation, with the number 4. Which is an extract from Bankley that Sir John Pennycook approved. For the purposes of winding up the partnership is deemed to continue the good faith and honourable conduct due from every party's co-partners during the continuance of the partnership being equally due so long as its affairs remain unsettled. That which was partnership property before continuing to be so for the purpose of dissolution. Sir John said it necessarily follows that where the property of a dissolved partnership includes a leasehold interest, then subject any other arrangement which may be made, each of the former partners owes the same obligation to the other former partner in respect to that interest as he did while the leasehold interest remained partnership property. And all of that is addressing the question in the second sentence of the quote, what is the position when a partnership is dissolved but there remains property of the former partnership which hasn't been realised? And just between E and F on the next page, having cited Chan and Zachariah, Lord Justice Morritt noted that Justice Dean in the High Court of Australia specifically agreed with the Thompsons and Heaton decision. So there is pretty clear authority in my respect for submission. While we're on Don King, can I draw your attention to one other point which in my submission one helpfully gets from that decision, and for that you have to go back to Mr. Justice Lightman's decision, which is earlier in the same clip, page 474 of the bundle. And the question was what rights the partnership could have in the so-called P, M and A agreements, the promotion agreements with the boxers, and the question that Mr. Justice Lightman answered, you can see at 474 just above G. As a matter of general principle, it is, I think, quite clear that a trust may exist of a contract, and this may extend not merely to the benefit of the rights conferred, but also the benefit of being a contracting party. This would occur when e.g. a trustee or partner enters into a contract as such, or a trustee or partner or other fiduciary becomes a trustee, constructive trustee of the contract. It's important to recognise that a trust for the benefit of the contract, and in particular of the benefit of being a contracting party, may be more beneficial to the beneficiaries than the mere assignment to them of the benefit of the covenants contained in it. For according to established principles, the trustee will hold any benefit arising from his trusteeship, in particular his being a contracting party, such as renewals of the contract on trust for the beneficiaries. And then he cites, among others, Patirana over the page. The distinction then is you've got the rights under the contract, but you have the benefit of being a contracting party. That's a factual situation. It's simply something that may arise as a factual consequence of the contract, not because there was any legal right to it, but because it constitutes, in practice, an opportunity. And it was then argued, well, these PMA and A contracts are wholly personal, and personal confidence is placed in the promoter, and these are contracts which can't be treated as assignable, if you like. They couldn't be saleable, and you can see at page 477 of the bundle, letter E, Mr. Assumption, who at that stage, though not in the Court of Appeal, was acting for Frank Warren, has submitted that a party cannot, without the consent of the other parties to the contract, make himself or become a trustee in respect of the contract, which involves personal skill and confidence and which prohibits assignments. And so the gist of the argument was, well, you've got a contract, indeed, in some cases, even with an express prohibition on assignment, and so the benefit of that contract can't be vested in someone else. And that was a proposition that, despite Mr. Sumption's advocacy, was rejected. At the bottom of 321, Mr. Justice Lightman said, accordingly, in principle, I can see no objection to a party to contracts involving skill and confidence or containing non-assignment provisions from becoming trustee of the benefit of being the contracting party, as well as the benefit of the rights conferred. And then in the Court of Appeal, going to the end of the page 491, one can see in paragraph 23, linchpin of, this is a letter B on page 491 of the bundle, the linchpin of Mr. Steinfeld's argument, he'd taken over from Mr. Sumption, it seems, on whether the benefit of the management and promotion agreements was property for the purposes of the Partnership Act, was a case of Noakes and Doncaster, which was about whether an amalgamation order transferred a contract of employment, and the House of Lords, as Lord Justice Morris decided that an order, an amalgamation order, didn't transfer the workman's contract from transferor to transferee. Lord Justice Morris, at the bottom of the page, paragraph 24, didn't accept that submission. He said that in the Noakes case, the speeches made it clear that their decisions were based on the proposition that property in the relevant section, i.e. of the Companies Act of 1929, was confined to property which was transferable by the parties. Because the employment contract was not so transferable, it didn't come within the section. Thus, the meaning of the word property was limited by its context. The House of Lords did not decide that the ordinary meaning of the word was so limited. Further, it's plain that property which is not assignable may nevertheless be partnership property. And he gives examples, including Patirana, where a personal license is a partnership asset. He says below letter D that in both Amler and Patirana the asset was inalienable. Above letter E, the reason is quite simply that partnership property within section 20 of the Partnership Act includes that to which a partner is entitled and which all the partners expressly or by implication agree should, as between themselves, be treated as partnership property. So an implied agreement may, of course, arise from the circumstances in the way that the context of the business and the way that it's operated. And then finally, at page 499, the last page of the report, paragraph 43, the second strand, that's of the argument, raises the question whether the renewal obtained by the partner for his own benefit was obtained or received by use or by reason of his fiduciary position or of any opportunity or knowledge resulting from it. It's plain that prima facie that question must be answered in the affirmative. Successful management or promotion of a boxer is likely to generate goodwill in both the legal as well as the literal sense. Such goodwill is likely to lead to a renewal with the same manager or promoter rather than others. So a factual likelihood, what Mr. Justice Lightman called the benefit of being a contracting party, but the goodwill and the opportunity and advantage to which it gives rise is the property of the partnership. So he's regarding partnership property as simply being the likelihood of some form of renewal, simply because of the fact of being the promoter and having that relationship while it lasts, not because of any legal right to it, but simply the possibility that naturally arises from the factual position. And that is, he says, that advantage, that opportunity is partnership property. So it's been treated as a thing of sufficient definiteness, as a phenomenon of sufficient tangibility or specificity to count as partnership property. Sufficient identifiability, one might say. And it can be controlled, to go back to Lord Legate's analysis in Ricazzi. I said before the break that we would look at the case of Jarvis, which is the newsagent case. It's Mr. Justice Upjohn, and that I imagine is in your first bundle. At any rate, it's tab 22, page 310 of the bundle. And you can see that that was a claim. 310, my lord, tab 22. You can see at the last break on the page, this was a dispute between two sisters, one of whom they were both the legatees of the will of the former owner of a newsagent business at number 7 Woolwich Road. You can see at the bottom of the page that when he died in September 1941, and he was then in occupation for a term of 3 years, expiring in 1944. He'd retired, but the business had been managed by one or other of his children. But over the page, the premises were badly damaged by bombing in December 1940, only partially repaired. The son handed over the keys to the defendant shortly after his death. As I said, that was in 1941. And after the bombing, until the premises were restored completely in 1944, no real business of selling goods retail was carried on. The defendant, and one has to know this in order to understand the facts, the defendant's sister had opened her own business at number 230 Trafalgar Road, which was in Woolwich, and the subject matter, the original business was in Greenwich, the father's newsagent. Dropping down to the middle of the page, you can see that after some correspondence, the landlords in March 1943 issued a writ against the plaintiff and the defendant for arrears of rent and possession. They were the ones, as I said, to whom the deceased had left the business. They signed judgment, so they got the premises back. She asked for a new tenancy, but was refused, but some months later the landlords offered to grant her a new tenancy, and that was entered into in May 1944. And you can see about 8 lines up, most of the firms with whom the testator had done business did not reopen accounts with the defendant, but she started with tobacco, newspapers and some novels, but no confectionery, no Kit Kats, I'm afraid, my lord, as she had no points allocation. The points allocation is a reference to the wartime rationing system, of course. As you can see, there's a quota of cigarettes and an allocation of newspapers, so literally everything was rationed. It doesn't say that the novels were rationed, but everything else was rationed, of course. If I remember correctly, it only ended in 1954, but before all of our time. But that's a case where, for different reasons than here, it is also a supplier's market, because you are in possession of a valuable commodity as the supplier. Everybody wants to get their cigarettes, their newspapers, and their confectionery, obviously. And so, unfortunately, the sisters fell out, and in 1951, the plaintiff's sister sued the defendant sister, claiming an account of what had happened in respect of number 7 Woolwich Road in Greenwich. Somehow both parties managed to get leading counsel, and Mr. Justice Upjohn, as he was, in the middle of page 819, said the second question is as to the position with regard to the business carried on by the defendant thereat. That's to say, as you can see from the previous sentence, number 7, so the father's premises or previous premises, of which she had managed to get a renewal of the lease by having corresponded with the landlords who had previously sued her. He refers to the conflict rule in Regal and Gulliver. The old business had been closed down after the bombing, but in a sense its ghost lay there waiting for a new lease of life. When the defendant resurrected the business on the premises at number 7 Woolwich Road, she was undoubtedly, to some extent, putting herself in a position where her duty and interests conflicted. In another sense, the business that she opened was a new business, but it was of the same character as the old. It necessarily benefited from the goodwill attaching to the premises because the newspaper and tobacconist business had been carried on there for 40 or 50 years. It may well be that the virtual closure for over 3 years, coupled with the great excess in those days of demand over supply, the very point I was on, made the value of the goodwill small, but it was there because of the former activities of the testator, of whose estate the defendant was a trustee. Furthermore, the defendant was able to get some supplies of cigarettes and newspapers by reason of the testator's earlier connection with the suppliers. It seems to me clear on principle the defendant must be accountable as a constructive trustee for the benefits which came to her because of her position as a trustee of the testator's estate. So there you have, in an unusual context, well, not then unusual, I suppose, but now unusual, the court going through the exercise, which might be conceptually quite difficult. Mr. Justice Upjohn manages to do it. And then what then is the proper method of assessing the accountability? Counsel for the defendant submits one must look to see what is pleaded and what's been proved at the trial. One must then take those assets of the estate or the benefits which have been so pleaded and proved at the hearing to have flowed to the defendant by reason of her position as a trustee of the estate and value those benefits. So that's a sort of narrow account, if I can call it that. Counsel for the plaintiff says, on the other hand, that that would be an impossible inquiry, and that one must make the defendant accountable for the whole business and its profits, making allowances for the time, energy and skill the defendant suspended by Lady Justice Falk's observation, precisely in point. The assets she's brought in, the debt she's paid, and of course the mother's annuity. No authority is precisely in point, and then he mentions Regal. I don't think it's possible to lay down any general rule in relation to businesses beyond the general principle already stated. trustee may not make a profit out of his trust. Or Section 29, a partner has to account for any benefit he has derived by use of the name, property or business connection. That's the equivalent that one has in the partnership context. To take an example, suppose that by virtue of our position as trustee, the defendant had been able to influence, as possibly which he did, increase supplies to the shop at number 230 Trafalgar Road, so that was her own shop, without reopening number 7 Woolwich Road. She would clearly be accountable, which surely, on the basis submitted by the counsel for the defendant, and a narrow basis rather than the basis submitted by counsel for the plaintiff. Each case must depend on its own facts. The form of the inquiry which ought to be directed must vary according to the circumstances. In this case, where the defendant reincarnated the testator's own business on the same premises as formerly, obtained supplies so far as she was able from the supplies of the former business, I think that the proposition propounded by counsel for the plaintiff is correct. Echoes, I would suggest, of Mr. Justice Richard's finding here, not appealed, that there was a seamless continuation of the business. Indeed, this case might be thought to be significantly stronger. The defendant in Re Jarvis had resurrected what Mr. Justice Upcon called the ghost of the business, although she'd done it by reason of the phantom presence of the old business as he found. But here, Mr. Hughes went a long way further than that, including the activities he took between 15th and 27th June, which I've told your lordships and my ladyship about on more than one occasion, to secure, as the judge expressly found, to exclude Mr. Mandukas from that relationship, secure it for himself. And so that is the wider basis subject to all just allowances, although in fact he then held that there'd been laches, and so in any event it wasn't happened. So that is, we say again, an example of the general principles that apply and how one can feasibly take an account. I'm going to move on now to talk about this completely different topic, which is the scope of the business. So this, I think, is ground 1D of Ms. Hilliard's appeal grounds, if I remember correctly.
This, I think, Ms. Hilliard dealt with very briefly.
I'm so sorry, my lord.
I think Ms. Hilliard dealt with this quite briefly.
Yes, and I'm going to be at least as brief. We say straightforward question of fact. The judge repeatedly found that the scope of the business was tests. For example, paragraph 39, subparagraph 2. I'll just give you the page number. It is page 93. Little 2, the partnership was to operate under the trading name Hughes Healthcare. Its business was to be focused on the sale of LFTs. And then page 97, paragraph 56, he refers to the different branding. Acon had its own branding that it used, but it was also prepared to supply the partnership's Hughes Healthcare branding. That's what he calls branded tests. Since the partnership was interested in promoting its own brand, its orders with Acon tended to be for branded tests, but tended to be is not the same as always were. Indeed, it's inconsistent with always being. If something is always of a certain nature, then you can't describe it as tending to be of that nature. Now, the two other pieces of evidence that bear on this, which I showed you yesterday morning, were first, in order first, the draft partnership agreement that Mr. Manduka prepared, which the judge referred to in the judgment at page 117, para 159, and then the SHA, the shareholders agreement, which the judge refers to pages 117 to 118, and at paragraph 166, the judge summarises it. We looked at the document itself yesterday, but the key point is very simple, that in both the draft partnership agreement and the executed shareholders agreement, which referred to the existing business as that which was to be transferred into the new cos, the business is quite plainly defined as the development, distribution, etc. of lateral flow devices without any constriction to them being branded. In our skeleton, we referred to an example, which is a very large sale of unbranded tests to a company called Argyle Rose, which was run by a Mr. Nabil Sheikh, and we put in the email that relates to that. That's in our unagreed bundle. It's page 9, divided 2. Starting at the bottom of the page, you'll see an email from Freddie Manduka of the 25th of March. Could we order 50,000 new FlowFlex single tests? So these are FlowFlex, and then Mr. Hughes writes back on the same day, in the middle of the page, sounds good in Hughes. In other words, with the Hughes Healthcare brand. And Mr. Manduka, Mr. Freddie Manduka replies at the top of the page, "Hi John, in the FlowFlex branding please," and we'll send straight to our client in Yorkshire. So there you have a substantial order which is processed for the sale of unbranded tests. Now, Ms. Hilliard said, without being able to point to any finding to support it, well, this is the exception. Now, in order to make that submission good, even if it were enough as a matter of principle, which I say it isn't, she would really have needed to be able to point you to a finding by the judge that this was exceptional and that there was indeed one solitary instance. So a submission doesn't have any basis, but as it happens, it's also wrong on the facts. So in our bundle of further material, in response to this assertion, tab 5 of what's called the extra materials, we've given another example. I stress this is in response to the factual assertion.
Give me the file again.
I'm so sorry, my lord.
Sorry, which file are we in now?
This is the day 4 extra materials. Is it in a Sportstone Buildings livery? Blue.
The one we got it this morning, didn't we?
Yes, it's a mixture of. It had the closing submissions in it, and
Yeah.
Sorry.
yep. So, as I say, in response to the asserted fact, tab 5 is a tax invoice from Hughes, which is dated the 9th of March. That's significant because it's 2 weeks before, so separate from the order that we were just looking at. And you can see that this has 3 components. The bottom 2 are Hughes, but the top one is ACON. So they're all antigen test kits, but 2 of them have the Hughes label and 1 has the ACON label. So we've got 2 examples, and that's not intended to suggest that these are the only examples. It's just by way of underlining the point that it is simply impossible to say that this partnership was limited to the sale of branded tests. And that's the short answer to that point. Now I'm going to turn on to the issue 1E, fiduciary reciprocity, and that is something which has 2 limbs, as was made clear in discussion, in particular with my Lord Justice Snowden. The first is that the duties of the non-defaulting partner are supposed to be discharged automatically as a matter of law by the fact of the breach or the serious breach or the egregious breach, it's put in various ways, of the defaulting partner. So there's the duty, the discharge of duty argument. The alternative way in which it's put is that you can't come to a court of equity to ask for relief if you yourself have done something wrong. So those are two alternative ways. We say those are both wrong. In a nutshell, the first limb is wrong because, as a matter of both of authority, for which there is none, and legal principle, it is not correct that duties cease to exist on the part of one partner when another partner is in breach of his or her duties. So there simply is no answer to the question that was, I mean, there's no reason, in a sense it puts the boot on the wrong foot, but it's well tested with respect by the question that was put to my learned friend. How and why does this happen? What is the legal mechanism by which a breach of duty not merely sounds in consequences, it gives a remedy to the injured party, which of course it does, but in some way ends the duties of the other party? And there was no answer to those questions, and we don't think there is capable of being any answer. Now, it's true that in common law, in a limited category, at common law, and using that in the strict sense, there is a limited category of case in which if one party doesn't perform its duties under the contract, the other party's duties are at least suspended. And the classic example, which we discuss in our skeleton argument, as you may have seen, is the employment case. There's a Lord's decision in a case called Miles and Wakefield District Council, which can be summed up in the common sense proposition, no work, no pay. So if the employee doesn't work, or in that case, refuses to do part of his work as for industrial action on the facts of that case, then the employer is not liable to pay the employee. You don't have to, if you're the employer, you don't have to dismiss the employee and say that all of the obligations of the parties under the contract have come to an end. Your obligation to pay is conditional on the performance by the employee of his obligation, his or her obligation to work. So that can happen in a specific set of cases. In the case of Miles and Wakefield, it's in the bundle, but I don't know if we need to look it up. But that was a case where the plaintiff was a registrar of births, deaths and marriages, and as part of industrial action in the 1980s, withdrew from conducting marriages on Saturday, which is, of course, a fairly, although it's a relatively small proportion of your working week, if you're a registrar of marriages, that is the most important part of the week. So a rather heartless piece of industrial action, one might think. But anyway, the question was whether the council was obliged to pay the registrar, or whether it had to go to the length of sacking him. And the House of Lords upheld the proposition that the council could simply refuse to pay because services weren't being provided. Now, the distinguishing feature of that sort of case is that the non-performance is completely visible and transparent. So everybody knows what's going on. The employee knows that he's not working. The employer knows that the employee isn't working. So everybody can see. And it makes sense in that case for the law to decide that there has been no performance of one party's obligation, so that another obligation, which is intrinsically conditional on the performance of the first, also doesn't come into play, doesn't come into force. And a similar sort of example might be thought to rise under contracts for the sale of goods. So if I don't deliver the goods to you, then you're not obliged to pay me, but it's all transparent and mutually visible.
I don't quite see why it should depend on visibility or transparency. I can see it should depend on pairing. The one
on whating?
Pairing. The one has to be the corollary of the other. I mean, suppose that you sent somebody to work in Antarctica and you couldn't see whether or not they were working, presumably the same principle would apply.
If what, my lord, I'm so sorry.
If you couldn't see whether or not they were working, should not the same principle apply, regardless of whether it's visible and transparent?
Yes, my point is simply that it is sensible to make those obligations interdependent, because the proof, as a matter of principle, is very straightforward and it's going to be accessible to everybody, and the information about it will be common to the two parties. What's said here is something very different, and for which, as I say, there is simply no authority in many centuries of law about partnerships, that automatically, when one party ex hypothesi will often be secretly, as is the case on the facts here, one party does something which is a breach of duty, that in itself has an impact on the duties of the other. And the difficulty, apart from the lack of authority, apart from the lack of any legal mechanism by which that might be thought to be the case, the interdependence, the difficulty that gives rise to in terms of it being a principle of law to be applied in everyday situations, is that you just won't know what's going on. So it will be impossible to know whether duties are or are not in existence. Take the facts of this case as found by the judge. I mean, the judge found, I took you to it yesterday, that Mr. Hughes in February sent an email, a sort of an email which deliberately undermined Mr. Manduka's position with ACOM. Now, let's just assume that that is also, as we say would be, a breach of Mr. Hughes's fiduciary duty to have a secret communication with ACOM to the detriment of his co-partner. So does that mean that Mr. Manduka's duties then cease to apply because Mr. Hughes had committed a breach? And the answer is you can't sensibly have a system of duties and obligations which operates on that basis. And indeed, that's why the Partnership Act has a different code, which is to say that you can dissolve the partnership and the court will then control the outcome. And indeed, if it's not a partnership at will, as the court well appreciates, you're then in the realm of Section 35, where the court has to decide whether to permit a dissolution. So you end up with cases like Mullins against Lawton, which is also in the bundle, where, as the court will know, Mr. Justice Newberger said, well, I don't find that the case where the partners in an insolvency practitioner firm bounced one of the partners into a meeting and basically tried to force him out and force his hand. And Mr. Justice Newberger said, well, this would be a repudiatory breach, but I find in following Lord Minute in Hurst and Brick that the doctrine of repudiatory breach doesn't apply. But I am going to find that because the conduct was so serious and was so unfair, inequitable, that it justifies my granting an order for dissolution. So in the partnership context, the court retains control, and that's the way in which non-performance of duties can be, one of the ways in which non-performance of duties can be taken account of. And the other way, of course, is once the duty is discovered, then the injured partner can bring an action for a remedy, for relief, just as Mr. Hughes has done in respect of the chosen to do in respect of the pre-dissolution activities of Mr. Manduka. And he is going to get, and the judge ordered, that there be an account of that profit. So that's the sanction. But the consequence that there should be an automatic discharge of duties isn't supported and would lead to all sorts of almost impossible complications in practice, which is why I said that...
It would only work if it was just a two-person partnership.
Well, how it applies to multi-partnerships is very difficult even to conceptualise. Yes, I agree with that. So there are, we say, major problems. The only cases that Miss Hilliard was able to point you to, one from 1851 and one from the Manitoba Court of Appeal, so a very impossibly slender foundation, but more specifically, In the first of those cases, McClure and Ripley, you had two persons who'd agreed to enter into a partnership for a voyage in 1851. And when the time came to stump up the money, the claimant, or the plaintiff rather, McClure, says, I'm not going to pay. So Ripley says, all right, that's it. So the whole venture is at an end. And one can see that even if repudiatory breach doesn't apply to partnerships, and first of all, it could be regarded as an agreement for a partnership, which Lord Millett said is covered by the doctrine. So if you have an agreement to enter into a partnership and you repudiate that agreement, then that repudiation can be accepted and that will bring it to an end. But even if it's regarded as a partnership that's come into existence, so repudiatory breach doesn't apply, it would still be, one would have thought in modern terms, a case of an estoppel. If somebody says, I'm not going to contribute to the partnership, I don't want to be treated as a partner, and the other partner then has to fund the whole venture himself, the partner who has withdrawn and expressly renounced his interests is surely stopped from claiming any of the benefits of a partner thereafter. And that would be the modern way in which we would deal with this. The Ackman case simply followed in Manitoba very, very similar facts. There was a partnership. The time arose, it was a piece of real estate in Florida, and it was necessary to put some more money in. And the plaintiff said, we're not prepared, we are withdrawing. They wrote and said in terms, we're withdrawing, we're not going to put any more money in. Well, once you've done that, there's no difficulty in concluding that after renouncing the whole arrangement and the whole of the partnership, you should be prevented from claiming the benefits of a partner. Again, estoppel would be an obvious way in which to do that. But none of that supports the completely different conclusion that someone who is a partner and has not renounced the partnership but has done something which court finds was wrong and which is itself a derogation from the duties of a partner in that specific area, doesn't show that that person ceases to have the benefit of any of the other rights of the partnership. And again, if one puts it in a multi-parter context where the rules have to apply in the same way, one quickly sees that it breaks down. How else are you to work out what duties are owed? Everybody continues to owe the duties within the firm in precisely the same way. And so we do say that there is no basis on which there's no mechanism by which the non-performance or the breach of a fiduciary duty stops the other partner or partners' fiduciary duties themselves from continuing. And that is, the absence of such a mechanism is no doubt why there is no support in many decades or even centuries of case law for this proposition. And if it were good law, one would have thought it was inevitable that it would have been adjudicated on and the subject of judicial decision. Now, the alternative way in which the point is put is to say that, that by reason of the conduct of Mr. Manduka, he's not entitled to relief. And we make three propositions in that regard. First of all, we say that this is a clean hands argument, and we say clean hands does not apply to Section 29 claims. And I'm going to show you briefly some authority, not under Section 29, but under the unfair prejudice provisions, which we say is analogous, partly analogous. The second proposition is that this was not pleaded by the appellants, and it wasn't raised. And I'd be grateful if Ms. Hilliard could contain her objections, and she will no doubt have time to make them at the end of the day. And we say it's too late to raise it now, obviously. Thirdly, we say that had it been raised, it would have been bound to fail, because the prerequisite for the application of a clean hand doctrine is, in the hallowed phrase, an immediate and necessary relation to the relief sought. That goes back to Derring and Wood, you'll see, I believe, but I'm going to show you some more modern authority, and we say that manifestly cannot be made out. So proposition 1 doesn't apply to the statutory claim, this doctrine of clean hands, because we say the statute does not permit it. And in my submission, the general position is that the clean hands doctrine does not apply to statutory claims. specific wording may introduce it, that's to say specific wording in the legislation may introduce it, or may introduce a general discretion which will be exercised, therefore, or can be exercised by reference to analogous considerations, but there is no such wording here. Can we look, therefore, in our additional authorities bundle, which, are there two bundles?
Is this morning's or the?
This is yesterday's.
This one,
Oh, this is the further one.
I'm very grateful for the court's patience. So,
This is the one with Abrahami, is it?
Yes, that's right.
yes, it is, my lady. Thank you very much. So I think we did get it electronically to you yesterday, and I'm very grateful my lady's already had the chance to look at it. So this was a dispute, an unfair prejudice dispute over a private educational institution called the London School of Electronics, which abbreviates to the LSE. I don't know whether that's a coincidence or not, but anyway, the quasi-partners in that fell out with each other, and so the question came whether or not relief could be granted, and as part of that, Mr. Justice Norse, as he was, had to consider an argument put forward by Mr. Oliver, which we see at the bottom of page 221 of the report. You can see just above letter H that Mr. Oliver said and relied on what was said by Lord Cross of Chelsea in relation to the just and equitable test in Westbourne Galleries, Abrahami, and he submitted that a petitioner under section 75 must come to court with clean hands. Although the practical consequences may often be the same, I do not share Mr. Oliver's view of section 75. I agree with Mr. Instone for the petitioner that the section must be construed as it stands. In other words, you look at just the wording, don't read things in. The combined effect of subsections 1 and 3 is to empower the court to make such order as it thinks fit for giving relief if it's first satisfied the affairs of the company are being conducted in an unfairly prejudicial manner. Conduct of the petitioner may be material in a number of ways, which the two most obvious are these. First, it may render the conduct on the other side, even if it's prejudicial, not unfair. Secondly, even if the conduct on the other side is both prejudicial and unfair, petitioner's conduct may nevertheless affect the relief which the court thinks fit to grant under subsection 3. In my view, and then this is the phrase, there is no independent or overriding requirement that it should be just and equitable to grant relief, or that the petitioner should come to court with clean hands. We can then go forward to tab 4 of the bundle, which is a Court of Appeal case called Richardson against Blackmore. Also an unfair prejudice claim. That was about a taxi company, quasi-partnership in Cardiff. And what had happened was that there were negotiations between the partners about the price of a buyout, and in the course of that, the petitioner forged a letter which made purported to make a very favourable offer for the company, and put forward a value. You can see that on page 280 of the report, paragraph 11. That's the petitioner, Mr. Blackmore, passed on to the others a letter which he said he'd received from Computer Cab PLC. In fact, it was a forgery. Sorry, it was Mr. Blackmore, created by Mr. Blackmore, the petitioner. And then you can see the letter, and it ends up with a valuation, purported valuation of the company. So that was a complete forgery. Mr. Blackmore was then forced out of the company, and that was his complaint of unfair prejudice, which was upheld. If we go to page 289 of the report, paragraph 51, the judge found that there had been unfair prejudice, and you can see that the grounds of appeal turned on the significance and effect of the petitioner's forgery. Paragraph 52, it seems to me the judge was plainly right that the forgery did not automatically discharge the obligations of good faith which he'd found to be imposed on the former partners towards each other. If Mr. Richardson and Mr. Wheeler had found out about the forgery at or soon after the date of the letter, they'd no doubt have reacted strongly one way or another. It doesn't follow they would have regarded any obligations of good faith between the former partners as terminated. They might have wished to reinforce them and insist that they be properly observed. There's no basis for finding that the good faith obligations were in some way discharged without any of the parties having had any choice in the matter. Now, I rely on that, in fact, in relation to the first way in which the case is put here, and Lord Justice Lloyd advances an analysis which is also points the way towards a principled response to the argument, which is to say, if you are the victim of some breach of duty, you should have the choice how you want to respond to it, and not, or you might want to continue the relationship, affirm the obligations of the defaulting party, and carry on in that way. And you should be given that choice, and it would seem to follow as a necessary consequence of the argument of the appellants here that that couldn't happen. So actually, Lord Justice Lloyd's analysis shows why it would be positively wrong in principle and unfair to the injured party, generically speaking, to allow that to happen. So that's authority against my learned friend on her first way of putting it. But in relation to the second way of putting it, clean hands, he then goes on to analyse it. He first of all cites the London School of Electronics decision, which he says is authority for the proposition, and just above letter H, that there is no requirement that the petitioner under section 459 should come to the court with clean hands. It is authority for that proposition, but it also shows that conduct which in another context might be used to invoke the clean hands doctrine can be relevant on a section 459 petition, in that it may nevertheless affect the relief which the court thinks fit to grant, and that of course invokes the discretion, the express discretion, which was conferred then by section 461 and now by section 996. Very broad discretion that a court has in relation to relief granted if the case of unfair prejudice is made out. And he goes on to say at 54, if misconduct by the petitioner is relied on as a reason for exercising the court's discretion under section 461 so as not to grant any relief, some of the cases on the clean hands doctrine may provide useful guidance by way of analogy. So just pausing there to see where we've got to. The general principle, I submit, is that in these cases, in these statutory remedy cases, you first look to see whether the statute which creates the remedy in itself permits the court to take into account clean hands, and as Mr. Justice North said, you must take the statute as it stands. So unless you have something in the wording of that legislation itself, the duty-creating legislation, you can't just import clean hands simply because this is a case that's being dealt with in the Chancery Division, as it were. What you can do is, if there is statutory language that gives a discretion, section 29 doesn't contain such language, it says that there must be an account, but if there is language, as there is in now section 996, then the court can invoke, as Lord Justice Lloyd puts it, by way of analogy, the principles the judge made law on clean hands. And what's of interest is the way in which that is then dealt with. If you go down to 55, he refers to the argument of Mr. Hollington for the petitioner in that case, citing a case called Mooley and Cox. I haven't got time to go through the facts. The critical point is what Justice Scrutton said at the bottom of the paragraph, that equity will not apply the principle about clean hands unless the depravity, the dirt in question on the hand, has an immediate and necessary relation to the equity sued for. And that is, of course, a hallowed phrase. And then Lord Justice Lloyd said that's entirely consistent with Willis and Gontier, where the misconduct lay in fabricating evidence in support of the claim itself. Well, one immediately sees the distinction here, that there is no question of Mr. Manduka having fabricated evidence in support of his claim. The complaint against him in this regard is that on the judge's finding, he agreed a secret profit share in relation to Newfoundland, but his claim against Mr. Hughes depends on the fact of the partnership, depends on the opportunity and the property name and business connection of the partnership and the subsequent deals that were done in the second half of 2021 and shortly thereafter. So none of the misconduct nor the evidence about the misconduct has any relevance to the claim that Mr. Manduka brought and that he's succeeded on. And Lord Justice Lloyd went on to say, I deplore the petitioner's conduct, that was the forgery of the letter, as much as the judge did. But he says, considering the point on the same material as the judge took into account, it seems to me that on his finding that it had no bearing on the matters directly in issue, finding he was plainly entitled to make, he was right to disregard the forgery, both in deciding whether the conditions under section 459 were made out and when in relation to his discretion under 461, as he says, the forgery itself had no immediate or necessary relation to the circumstances upon which the petitioner's entitlement or otherwise to relief depended. And the same we say with respect applies here. He said there was then some further evidence put in which wasn't before the judge, and 291 between letters E and F. Lord Justice Lloyd said, his conduct is neither sufficiently serious nor sufficiently closely related to the respondent's unfairly prejudicial conduct to make it appropriate for the court to exercise its discretion. So we say then that that's the general principles. That's proposition 1, and also in effect proposition 3. Proposition 2, just to revert to that, we do say that it wasn't pleaded here. It was pleaded, but only as a defence to a claim for specific performance of the shareholders' agreement of the SHA. And if you go to the core bundle tab 13, and that in my bundle is physically separate, but it may or may not be for my lords and my ladies. That is the defence and the counterclaim. So, not sure we've looked at yet. It's not a short document, but I want to go to page 351. And you can see paragraph 144. This is dealing with titanium. So titanium obviously doesn't bring any partnership claim. By definition, it only brings claims under the SHA. It's not entitled to specific performance of obligations which no longer exist by reason of the rescission, alternatively termination of the SHA. The judge rejected expressly the argument that Mr. Hughes was entitled to rescind the SHA. He rejected expressly the argument that Mr. Hughes was entitled to terminate the SHA for breach. Neither of those appealed, but specific performance is then said to be a discretionary remedy. And at C, titanium is equated with Mr. Manduka, and then over the page it said that Manduka doesn't come to court with clean hands. So that is the reference that we find to specific performance, to clean hands in the defence and counterclaim, but it wasn't advanced on any wider basis. So on those 3 bases, that's to say, clean hands doesn't apply, it wasn't pleaded, and in addition, it wouldn't be made out anyway. We invite the court to reject that ground of appeal, or that limb of that ground of appeal. That then brings me to the section 42 claim, which I can deal with quite shortly. So the essential point here, we say, is a very simple one. That there is, on the assumptions that are required for section 42 to be triggered, an outgoing partner. There is then a continuing partner who carries on business. In relation to the business which the continuing partner carries on, the outgoing partner is entitled to a remedy under section 42 in respect of that business. It may also be the case that the person who was the outgoing partner carries on some business of his own. And in respect of that business, he is the continuing partner, and the continuing partner is the outgoing partner. And there is no reason why one has to regard the business of the partnership as some indivisible entity which can only be continued by one person, and you have to choose who it is. I mean, just imagine, for example, that you have a partnership with two shops, and the partnership splits up, and partner A takes one shop and partner B takes another shop. They each continue the business, and one shop, and they have different fates commercially, but we say there's no reason at all why each shouldn't be accountable to the other as a continuing partner in respect of that part of the business which they carried on. And it's as simple as that. The judge, therefore, was...
In that case, how many sets of final accounts would there be?
Well, on that hypothesis, you would have two successive businesses, and there would be two sets of accounts.
It doesn't fit very easily within the words of the rest of the words of 42, does it?
Which part, my lord?
It talks about a final settlement account between the firm and the outgoing partner. And you're saying that there are, for these purposes, as I understand it, you're saying there could be two bits of the partnership business, and the two people could be both the surviving partner and the firm for one purpose, carrying on the business of the firm for one, or part of the business of the firm for one purpose, but the outgoing partner for another purpose.
Yes.
And how does it work?
Well, I mean, as a matter of practice, my lord is right that there would be more work to do, but that's because there's been two separate streams of business which would need to be accounted for.
Do you apply section 42 twice, as it were?
Yes.
Apply it to each business?
Yes.
Because in your example, one shop might be freehold, one might be leasehold. There may be different values.
Yes, and one might be selling one type of goods and one another, and the business done is separate, and each partner has to account to the other for what they've done. I mean, in practice, of course, one imagines there'd be some appropriate discussion, but that's obviously not the point. But it's simply inherent, and I mean, there are endless number of permutations one can imagine.
One possibility in your example is there are actually two businesses rather than one, but that's not complicated.
No, but I mean, there are multiple. I mean, there are lots of partnerships which have many strands to their business. If you have a multi-partner business, but again, it could still be dissolved, and you might have all sorts of successive facets of the business. And yes, they would have to be accounted for, and I fully accept that could be very complicated. It is a function of the fact that the Partnership Act does apply concepts of accounting to what, in modern conditions, if you were having a partnership, might prove to be a very complicated exercise. And I mean, in a generic way, it's part of the reason, obviously not with a few disputes under the Partnership Act, but the general complications, part of the reason why everybody incorporates, and why partnership ceased to be the major mode of commerce which it was in its Victorian heyday. There's just too many complications. But we do say that that is the short and simple answer to the section 42 point. I'm going to move on, and I may be able to give Miss Hilliard a couple of extra minutes. Grounds 6 and 7, case management. So what happened here is really expressed summed up by Mr. Justice Richard in his consequentials judgment, which I think the court looked at. It's in the court
Yes, we
under
did, didn't we?
tab 10, if I remember correctly. It's page 118. Parties should bring necessary points before the judge by way of submission. The duty is not discharged by pleading a case, but saying nothing in oral or closing submissions about how aspects of the law should be applied. The facts of that case in the light of the evidence given. Part of that discipline is so that the other side has an opportunity to say something on the matter, an important point. If a judge just rummages around and reaches conclusions unguided by submissions, the procedural safeguard would be disturbed. Now, I think I showed you very briefly at the end of day 2 what the extent of the submissions was, and it is executive. I can take your lordship back to it if it would help. It is in our. Is it our unagreed bundle? Yes. It's in our unagreed bundle. So the written submissions from the defendant, tab number please, tab 22, page 92. So as is common ground, Mr. Justice Richards had said, can you redo your written opening? I had to in the light of the trial, so I got one composite document rather than an opening and a closing, put it all into one, and he was fairly clear about that. And then you can see, so there's the legal submissions about the elements of an unlawful means conspiracy, but on the factual point, it's page 97 of the bundle. The conspiracy against C's. It's exiguous in the extreme. I mean, it's just an assertion that the conspiracy is amply made out. The court's invited to read WhatsApp messages. There's a statement that they demonstrate as clear as day that the family will be working together. And then attention is drawn to a couple of matters. And then 409, the defendants will deal with the conspiracy, service assistance and knowing receipt in oral submissions. Now, stating the obvious, I mean, that is not telling a judge how you think he should, and the basis on which you think he should decide the case. It's merely asserting in a sentence the conclusion, and it's a promise to make submissions orally.
But you know you've got a pleaded claim. It's a claim that was put forward again in the written opening. It's a claim that's being pursued in the written closing. Is a judge entitled to say, well, I haven't heard anything more about it, so I'm not going to decide it?
Yes, well, he doesn't say, I'm not going to decide it. He says, you haven't satisfied me that your claim is made out.
He doesn't say anything about the evidence. He doesn't say there isn't the evidence to prove
No.
it. He says he hasn't heard submissions enough to prove
Well,
it.
he says a little more than that. He says it was part. He says it was your. Well, we're going to look at what he says, but he says it was part of your burden to persuade me and to do so by way of submissions. I mean, if just put it another way, my lord. Let's imagine you had somebody who said, I positively refuse to make any submissions. I've called some evidence and I've pleaded the claim, and it is up to you to decide. That's it. I'm not going to say anything about it. So that's effectively what happened here. Because
Well, they've got an expiration of the law,
Yes, I've got an explanation of the law, but I'm not going to tell you it. So I'm not going to give you anything more than that.
And then I'm sure you'll remind us of this too. It isn't as though in oral submissions they said they were abandoning the case. To the contrary, they said, no, we do say there's an unlawful conspiracy.
Yes, they stated it, but they didn't develop it. They didn't explain how the evidence fitted with the elements. So the elements are potentially quite complicated. In relation to a conspiracy, you have to show, in relation to each person whom you want the court to find liable for the conspiracy, how they combined, as it's put, and whether they can ascribe to them the necessary intention. And it doesn't follow that just because you're able to say that one person has done something or has the necessary intention that any, let alone all of the others, also do. So what the I mean, I'm being reminded there was very limited evidence on it as well, but the job of a party is to put before the court not only the pleading and whatever evidence it chooses to adduce, but to explain to the court. We have an adversarial system under which people have a burden of proof, and part of that burden is a burden to satisfy the court, not only by the brute fact of the evidence and the pleading, but by explanation how it is that your case has been made out. And the judge said, as is invariable practice, I would like submissions. That's a perfectly proper, reasonable and inevitable requirement. And he didn't receive any submissions of substance. He had this promise of oral submissions and then they ran out of time. And that's unfortunate, but I mean, that's a matter of the choice of the advocate. And the remedy, if they felt they'd been unfairly treated, this professionally represented party, knowing that they hadn't in fact developed any of their submissions, would have been, what quite often happens, is to say, well, please can you give us some extra time or give us the opportunity to put something in writing. That would also have had the further, not just advantage, but we say necessary advantage, as the judge pointed out. It was then given the opposing party, the defendants to counterclaim, my clients, the opportunity to respond to the way that the case had been developed, which they by definition lack if the case is not developed. So if all you have is a pleading and some evidence and you don't know how the dots are joined, what are you supposed to do as the party responding to that claim? You can't be expected to argue against yourself in some sort of legal Dutch auction. You're entitled to wait and see how the case has been put against you, how the explanation has been given, what the proposed reasoning is, which the court is invited to adopt, the findings, the legal link, the conclusion, and then to respond to that. But you can't do that if the case has not been developed. And the remedy that Miss Hilliard had was to say to Mr. Justice Richards, I know that I've run out of time. Obviously, nobody can demand unlimited amount of time from a court. The central feature which this court, like all courts, has to deal with all the time. So on that basis, it would have been perfectly open to Ms. Hilliard to make a plea for some further judicial resource. However that was done, the judge would then have had to consider that. And if he'd reached a decision then which was unfair, then this court would have had the ability to review it. But he wasn't faced with that application.
Now, I mean, we do see in the transcript when Miss Hilliard is running out of time, this is page 59 of the bundle, we do say there was an unlawful conspiracy here, we rely on blah, 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 blah. Now, you say Miss Hilliard should at that point have said, well, I'd like to develop this further or something. But the judge didn't say, look, because I haven't heard any more about this, I'm not going to consider your pleaded case which you're pursuing.
Well, in my respectful submission, Miss Hilliard must have appreciated that she hadn't been able to develop the submissions that her written submission said she would do. So it's not as if the judge was concealing anything. The judge had not heard submissions, and the onus was squarely on her to make that application, knowing, as she knew, that she had not had the time to do that which she had promised to do. And the judge had said, I want your submissions. He hadn't got them. and it would be, in my respectful submission, contrary to the proper approach for this to be for this complaint to be upheld. In the bundle of further material, so in the additional materials that we handed up, we found a case which has some bearing on this. So it's the day 4X material. It's called LaBrouche. Decision of Lord Newberger in this court. Paragraph 22 on page 3165. This was a case where Mr. Justice Peter Smith decided that he wasn't going to hear an application because he didn't think it was a good one, and that there was no point. If you look at page 3163. He starts off by saying this be struck out as beyond the reach of sustained argument, and then Mr. Newman said, well, maybe I should just appeal, and Mr. Justice Peter Smith says in the middle of the page, I don't intend to force you to try and persuade me to the contrary. It is a pointless exercise, I understand. So it's somewhat the converse of this case. And Lord Newberger said, Para 22, it's a fundamental feature of the English civil justice system, and indeed any system, that his party should be allowed to bring his application to court, make his case out to a judge. Of course, this is subject to some exceptions and limitations which exist to ensure the proper administration of justice. And then he talks about when you can refuse to hear arguments, and he talks at the end about time limits which are imposed to ensure that a party is not allowed an extravagant amount of time to the detriment of other court users, and the judge here have taken a view as to what amount of time is appropriate to allocate, which is an important part of the functions of first instance judges. And the Court of Appeal felt that it was obliged to allow the appeal so that someone would have to hear, another judge would have to hear the applications. But at 41 on the last paragraph, last page, Lord Newberger said this decision should not have the effect of deterring first instance judges from being properly robust. For instance, if before coming into court a judge has formed a preliminary view on some or all the points at issue, nothing wrong with expressing that view, etc., etc. He says, on procedural and case management issues, trial judges should be encouraged to be robust. While it's in the duty of this court to reverse a decision if it's wrong, it's only to be invoked when the decision was, and then he cites the familiar tests and goes on then to talk about the various reforms. It is, according to that, appropriate for judges to be encouraged to be robust. This judge had said, I want to have your submissions and I want them in writing, and then I'm going to give you a fixed amount of time for oral argument. And so the defendants had that opportunity to put things in writing and to explain their case in writing, and they had the opportunity, a reasonable opportunity, to develop in their case orally. And if the judge, at the end of that, had not heard any submissions to allow him to understand how the case was to be put together, he was, in my respectful submission, fully entitled to say, you have not persuaded me of your case. They had had a reasonable opportunity to do so. It was the opposite of the LaBrouche case, where they completed a denial of opportunity, and that is that. It only adds to the response to this ground of appeal, or these two grounds of appeal, to say, in addition, as a professionally represented party, you could perfectly well, knowing that you hadn't done that which you said you would do, and which every party normally does in heavy commercial litigation, to explain a complicated case to the judge, how the judge is supposed to join up the dots. Knowing they hadn't done that, they could have asked for more time, and they didn't do so. And that also is pointed out by Mr. Justice Richards in paragraphs 13 through to 16.
The judge makes mention in paragraph 16 of the fact that he wrote himself to the parties after trial, pointing out what he saw as the paucity of the submissions on the dishonest assistance issue. Presumably well, I mean, A, do we have that communication, and B,
Yes.
did he also sort of say anything about the paucity of submissions on the conspiracy issue to sort of as a precursor to saying what he did in relation to the conspiracy claim in his judgment?
Yes, we have the subsequent chain of correspondence. I'll be given the reference to that in a moment. I can't immediately answer, I'm afraid. I think it's tab 7, is it? Page 20 of the agreed supplemental bundle. Tab 10.
Well, it goes 7 and 10.
Yes. 7, 8, 9 and 10, so quite a lot of... And 12, right, okay.
This is the agreed supplementary.
Yes.
Yes, this is the agreed bundle. And I mean, I'm looking at page 60.
60.
60, my lord, thank you. So you can see at the top he sees nothing or very little, and then he refers to various aspects, not including the conspiracy claim, but including other claims. Can they refer me to any parts of their closing that I may have overlooked? And the answer given is, well, here's what we've said.
So this isn't about the conspiracy claim.
I'm so sorry, my lord.
This isn't about the conspiracy claim.
No.
Yes, I mean, the judge, it's just curious, the judge
Yes.
didn't give a hint that he thought that the submissions in relation to the conspiracy claim
No. But
were inadequate, but he
he
did
doesn't.
give that indication in relation to the
The knowing receipt.
dishonest
Dishonest
assistance knowing receipts.
Yes. No, my lord, it is an oddity, but it doesn't, in my submission, come anywhere near to making it unfair. Not least because what happens is he goes.
Suggests that he still thought that even though he had had inadequate or no submissions on some points, that he was supposed to be deciding them and was asking for help. Rather suggests that he still thinks that otherwise, why is he doing this?
Well, paragraph 7 does have one element about
But the point I was going to make, unless my lady wanted to put something to me, I've got about 30 seconds.
I'm mindful that we're coming up to a court-imposed time limit.
Well, indeed. So the point I was simply going to make is it wouldn't have made any difference. The defendants took their stand on what they had submitted, as you can see in the light text answers under 5, and said, this is what we pleaded. And the judge made it plain. He wasn't inviting it, but it was up to them. My basic point is if you know you haven't made submissions, then you know that's a difficulty, and it's up to you to ask for more time or more space.
And anything different to say about the knowing receipt claim?
Well, other than the knowing receipt claim, no, I don't have anything separate to say about that. What I do suggest is that there was, this is not a case of a party who's been denied a reasonable opportunity to put its case, and that's the test.
Thank you very much.
Thank you very much.
Ms. Hilliard.
Mr. Bayard dealt in some detail with Mr. Hughes, in his words, misconduct. So I just want to address the facts in relation to that very quickly. We've got two very brief points on that. First, almost everything my learned friend took you to happened on or from the 15th of June, less than 2 weeks before the dissolution of the partnership. And in fact, it started the day after Mr. Hughes sent an email and said, you know, now I found that you've set up a separate company and you're doing business separately from me. And I accept that the judge, you can't go behind the judge's finding that that company was set up pursuant to an agreement that was made in February 2021. So I can't go behind it. But that is what triggered, and the judge didn't find that that was deliberate. He used it as a sort of as an excuse. That is what triggered what happened after the 15th of June. Second, as the courts has already observed, the judge made no finding that Mr. Hughes committed any breach of fiduciary duty pre-dissolution, or indeed any breach of fiduciary at all, save for his failure to account under Section 29. My learned friend also said, and it's just a factual inaccuracy here, that Mr. Hughes cut Mr. Manduka out of dealings with ACON. That was wrong. We say that the reason Mr. Manduka couldn't deal with ACON directly, although of course he dealt with ACON indirectly through Newfoundland, is because ACON drew their own conclusions about Mr. Manduka. And I just ask you to read later the Appellants Unagreed Supplemental Bundle, tab 33, at page 100. It's a entry, it's a WhatsApp between ACON and Freddie Manduka after the dissolution. And Anita of ACON is saying to Freddie, I admit that you nail in the sales and it's hard to walk away from large order, but it's just that it seems to me working with your parents is dangerous. So that was why they didn't want to deal with Mr. Manduka. He was dangerous. Now, my learned friend made a number of references to matters such as potentially the allegation of there being a maturing business opportunity. And I think, as I understood his submissions to you, is that he was saying that that should now be left over to trial 2. Our first ground of appeal is that the judge was wrong to declare that Mr. Hughes is liable to account pursuant to Section 29. The parties, and you can see that from the list of issues, the parties concede of trial 1 being a liability trial, and of course there were a whole lot of other issues rather than the partnership issues, because this claim started off as being a claim by Titanium for breach of the shareholders agreement, and it wasn't until we effectively said, well, actually, by the way, there was a partnership before this, that it developed in, and we sought a winding up of the partnership and so on and so forth, that it turned into, as well, a partnership suit. So the list of issues, and if you go through them, it's quite clear that what the issues required is for the parties to make their case on what the position was, what the liability was, in relation to, amongst other things, the partnership issues. And in particular, what their case was on business connections. And you've got our point that ACON was never pleaded as being a business connection, which did, I mean, you know, we didn't jump up and down at the trial and say that's outrageous and it can't be run now. So I accept we can't sort of go back over it. We can't rewrite history, but the court is entitled to take into account that it did mean that the trial kind of took on a direction which certainly we weren't prepared for at the beginning of the trial. It wasn't until opening that this ACON as a business connection was first made. Now, the opening skeleton of the claimants was that CAP was an intermediary. There was no mention of CAP being a business connection. You were taken, I think, to the claimant's closing, and you can see there was just a passing reference to CAP being a business connection without any explanation about why CAP should be a business connection. And we say it would be quite wrong when we already had a 19-day trial to say, well, the issue, and I think my Lord Justice Newey made the very obvious point that you could end up with a situation where nothing is decided, and the question of whether CAP was a business connection goes over to trial 2. Well, I mean, that would just be appalling after all the money that was spent on the 19-day trial. So those are my initial introductory comments. As regards our reply on ground 1A, my learned friend, I think, accepted that Section 29 effectively codifies and embodies the fiduciary duty to account for making a private profit. And we agree. But what our point is that Section 29, and in particular the reference to business connection, shouldn't be construed so broadly as to penalise a partner for something which wouldn't also be a breach of his fiduciary duty. As regards our reply in relation to ground 1B, Mr. Baer submitted, and it's page 159 of the transcript yesterday, that the Section 29 duty continues the same, irrespective of dissolution. So the duty of a partner to account for the use that he makes of partnership things is the same, he said. We say that's not right, and it's also a departure from the judge's reasoning in the judgment and the agreement of the parties at trial. And for the avoidance of doubt, we do accept that the duty of faith continues post-dissolution, as does Section 29 too, which talks about completing transactions concerning the partnership post-dissolution. So we say the duty does continue, but it's not the same, and that was common ground between the parties at the trial. That was paragraph 257 of the judgment. So, and it, as I say, the judge appeared to accept that because at paragraph 264, he expressed his view about Don King and explained about, he understood the concession that Mr. Briggs made as being because the partnership had ceased business and therefore self-evidently brand new contracts didn't need to be accounted for. We also say that the law is clear that your duties do change post-dissolution. Take the partnership name. We obviously accept that if a partner made a private profit from the use of the firm's name pre-dissolution, he'd have to account. But as my Lord Justice Newey has pointed out, Lindley and Banks recognises that both partners are permitted to use the name post-dissolution, provided that the firm's goodwill has no saleable value. And third, we say that the Parliament has made a deliberate choice to allow partners to compete with the partnership and the other partners post-dissolution, provided we say that they don't do so with partnership assets that should be realised as a consequence of the winding up.
Can I just go back to your point about saleable value?
Yes.
I think there was a distinct point of difference. What I think Mr. BR was quite clear. He said saleable value is not the test. I mean, you can have value to a partnership even if it's not saleable, such that a partner shouldn't be entitled to use it, whatever the thing is.
Well, my
How do you deal with that?
Well, my primary argument would be that it should be saleable value. It should be capable of being monetized in some way.
Why is that? I mean, I understand your position, but
well,
what's the
I think
rationale?
because relying on what Lady Justice Arden said in John Taylor's, she talked about when she said that the partners had to bring into account the provisional license that they'd obtained and also the subsequent permanent license. She said, even though the provisional license wasn't strictly partnership property, she said you have to treat it as though it was partnership property.
It's a slightly different point. I mean, I think Mr. Biar was saying, the test is not really assignable property. It's, is it valuable advantage? If I can try and put labels on this. And he said that is consistent with the general principle, and I'm paraphrasing, of course, that the general principle that partners shouldn't be entitled to make whatever use of partnership advantages for their own benefit. And he says that's a much more broad concept than just simply looking for pieces of property.
Well, firstly, that's not what Lord Linley says, and I think we've handed up a bundle to you, tab 12 of the bundle.
I must have been. I'm getting a bit confused on my bundle. Is this Churton?
Yes, Churton and oh, it's the wrong one. Sorry, it's tab 11. So, yeah. So at paragraph 17, the subject upon which it's always desirable to make some express agreement is the extent to which a retiring partner shall be restrained from commencing business on his own account and in opposition to the continuing partner. In the absence of any agreement upon the subject, the retiring partner is as much at liberty to set up for himself in opposition to the firm he has quitted as he would be if he'd never belonged to it. And on the general dissolution of the partnership, all the partners are at liberty to commence business in opposition to each other as freely as if they had never been partners, unless they've entered into agreement not to do so. What are you looking for? Oh, apparently there's a, yeah. And then the 6th edition of the Law of Partnership, tab 6. The saleable value of the goodwill of the partnership business, whatever that value may be, must be considered as belonging to the firm, unless there's some agreement to the contrary. And it follows from this that if a firm is dissolved and there's no agreement to the contrary, the goodwill must be sold for the benefit of all parties, if any of them insist on such sale. That so far as possible, having regard to the right of every partner to carry on the business himself, the court will, on a dissolution, interfere to protect and preserve the goodwill if it can be sold. That if a partner has himself obtained the benefit of the goodwill, he can be compelled to account for its value for what it would have sold for, he being himself at liberty to compete in the business with the purchaser. So from that, we draw the conclusion that goodwill is only a partnership asset if it does in fact have saleable value. Come on, Stuart. Yeah. Yes, and so from that we conclude that you can use the name unless the name has value that it could be sold, not just some kind of advantage, as you say. It has to be capable of valuation and real. And it's interesting in this case, my learned friend saying how valuable the Hughes healthcare name was, but there was never any proposal or offer from Newfoundland or Mr. Manduka to actually either try and sell the name or to buy it from the partnership. They knew, as well as Mr. Hughes did, particularly after the partnership, after several months, that Hughes Healthcare had no value whatsoever because everybody wanted Flowflex tests. So So, coming on to ground 1C, Mr. Bayard says that business connection is to be interpreted as ordinary English language, and it simply means the partnerships, business relationships, and the advantages. He repeatedly said that yesterday. We say that's wrong for at least 6 reasons. First, that's not how the respondent's case was put at trial. Secondly, it wasn't what was found by the judge. The judge clearly did not construe business connection as being all of the partnership's connections. Not only did he not describe many of the partnership's contacts as business connections, but it's also consistent with his statement at paragraph 280 of the judgment that whether something amounts to a business connection is a question of fact and degree to be considered in the light of all relevant circumstances. And you heard my submission in opening that doesn't really provide an answer. First of all, we have to work out what business connection means as a matter of law. To leave it to a question of fact and degree gives no indication to the commercial world when a connection will need to be brought into account and when it won't. It just creates uncertainty. And I don't need to labour the point that there's no respondent's notice saying that the judge was wrong in the way that there was another basis upon which the judge's judgment could be upheld in relation to business connections. So third, even if this new case is somehow open to Mr. Bayard, we say it's wrong as a matter of law. I don't propose to repeat our submissions on business connection, but you have them in the note that we handed up. And essentially, historically, business connection in the partnership context has really related solely to customers. Mr. Bayard valiantly tried to suggest that the boxers were suppliers in some way, but no, they're consumers of the promoters' services, just as the partnership were consumers of the supplies that ACON provided. So the closest you get to it is, I suppose, Lady Arden and what she says in John Taylor's. And as we pointed out yesterday, at first instance, the judge was talking about the customers being the business connection, but on appeal, Lady Justice Arden said that the council as well was a business connection. We, as I explained in opening, we don't have any difficulty with that in the sense that the council and the partners had a very, very, very long relationship, and the key point there was that the partners pre-dissolution went to the council and said, can we have the next contract, the next license, which was going to expire exactly on the day of dissolution. There you can see how it can be said that the partners did take advantage of a partnership connection, which Lady Justice Arden found was of long duration. And although water was poured on this by Mr. Bayard, it was an exclusive relationship. There was only one licence, there was only one auctioneer's premises. Mr. Bayard's argument seemed to be that the ACON business connection meets...
Is it implicit in your last set of submissions?
Yes.
It's a question of degree, facts and degree. I mean, I'm just...
No, because I think that if there is a contract in existence pre-dissolution, and all the cases that we were looking at the partners went to the party, the other side of the contract, and said, "Can we have a new contract post dissolution?" So it's very much well. There's one way that's one way of putting it. It's very much looking at what the partner did pre-dissolution to leverage a pre-existing valuable contract for themselves after dissolution. If that's not right, then we say that a business connection has to have the quality. If it's not something that is leveraged, it has to have a quality that is, as we've said, exclusive or close to exclusive. That it is of sufficient longevity that you can actually point to it and say, yes, okay, the partnership has built up a sufficient loyalty in that supplier to actually say that it is a business connection, and it's one.
When you use words like sufficient and things like that, it does begin to sound like.
Well, it does. But if that's going to be the test, my lord, it's not met here. The ridiculous thing is that the first test was bought in November 2020. The partnership was dissolved in June 2027. 7 months later, 5 months later, Mr. Hughes or his company MSLD did the deal with the Danish government. Now, Mr. Bayard accepted that there comes a time when, if there is a business connection that a partner exploits, if it's not of the type that I was talking about before, that it's exploited pre-dissolution, that the strength, the advantage effectively dwindles over time. Now, how can it be said? You can't say on the one hand that the partnership had, after 7 months, built up a sufficient loyalty with ACON to have a business connection, and at the same time argue that the business connection with ACON carried on, notwithstanding that it was Mr. Hughes for the next 5 months, so nearly as long as the partnership was doing business with ACON. I mean, by Mr. Bayer's reasoning, by the time of the Danish deal, any connection that the partnership had, quite apart from the litigation and Newfoundland, but any connection that the partnership had built up in those 7 months must have evaporated. Because if you can build up loyalty in 7 months, surely, it's impossible to say that another person can't build up loyalty in 5 months. We say that the shortness of the partnership was not sufficient to build up a sufficient level of loyalty, goodwill, if you like, for the relationship with ACON to be a business connection. But if that's wrong, then we adopt Mr. Bayard's argument that 5 months later, it couldn't have had any further influence on whether ACON was going to do business with MSDL or not. Right. Mr. Bayard drew your attention to recovery partners and seemed to suggest that Mr. Hughes made his profit out of his fiduciary position. But as I said when I just started my reply, there's no finding in the judgment to that effect. And Mr. Bayard didn't draw attention to anyone. Mr. Bayard also drew your attention to the case of Churton and Douglas, which is cited in Trago and Hunt. He appeared to rely on this as to the meaning of goodwill. However, we say that the most important aspect of this judgment, which is at tab 12 of the bundle that was handed up to you, it's a partnership case, and at page 390, at the bottom of the case, the Vice-Chancellor said, just right about 5 lines up, upon a sale of the goodwill of a business, the vendor is not precluded from carrying on a precisely similar business with all the advantages he may be able to acquire from his own industry and labour and from the regard people may have for him, and that in a place next door, for example, to the very place where the former business was carried on, and upon the authorities it settled that if the purchaser wishes to prevent that step from being taken, it's his fault if he does not take care to insert provisions to that effect in the deed. And of course, I mean, partnership, as it's an agreement, there was nothing to stop the partners agreeing as to the use that could or could not be made of ACON if there was a dissolution. But they didn't do that. And we say that on the basis of Churton and Douglas, on the basis that all the cases, except the slightly unusual case of John Taylor's, all the cases of dealing with business connections are customers. And that's not surprising because, of course, customers are the lifeblood of the business. I mean, the partnership could have bought all the tests that they wanted from ACON. If they didn't have customers, in fact, if they didn't have Newfoundland to go out and sell those tests, they wouldn't have made any money at all. So it's the customers that are important. On our ground one, I'm not going to address you on ground 1D. I think I said what I needed to say about that yesterday. I'll reply on ground 1E. Mr. Baer made great play of the fact that Mr. Manduka offered to account for the tests he sold personally to Collinson's and Radisson. And I do remind you, the judgment does say that Collinson's was the biggest customer of the partnership other than Newfoundland. When asked by my Lord Justice Newey, he did concede that he didn't offer to account for all that he was receiving from Newfoundland on an ongoing basis. And in fact, he only offered to account for Collinson's in his reply. It wasn't an offer that was made in the particulars of claim. Just so that you, if you're interested, so you can understand our difficulty in bringing a claim against Mr. Manduka for his ongoing profits in Newfoundland. The problem was because Newfoundland was never subject to a non-compete clause like other people were, and also as of the 15th of June, they went direct to ACON, and therefore, if they wanted to pay Mr. Manduka a profit from their sales, it was very difficult to see on what basis we could continue to say, well, you've got to continue to account for what you're continuing to receive from Newfoundland. It wasn't a tactical decision. It was just a decision reached on the basis of the difficulty, bearing in mind that Newfoundland had cut itself free from the partnership. As regards our reply on ground 2, we simply endorse the observation that was made that Section 42 actually does refer to the outgoing partner and the continuing partner, and it doesn't talk about lots of outgoing partners and continuing partners, and the idea that you would have lots of different separate accounts for separate businesses being carried on seems to be a recipe for disaster. And it's fair to say there isn't a single case that you've been cited to you where it's been argued that both parties have to account because they were both continuing partners. And we say for a very good reason that Section 42 only applies when there is an outgoing partner and a continuing partner. I'd also invite you to have a look at our unagreed bundle, tabs 34 and tab 27, because first of all, that shows that Mr. Manduka was getting Hughes healthcare tests through another manufacturer called Getin and putting them into Hughes healthcare boxes post-dissolution. He tried to enter a tender on the DHSC with a company called HealthNet Home Care, planning to supply from Acon, or at least using the confirmation letter that Acon gave to the partnership. That's at tab 27. You'll see from the documents in our unagreed bundle that Mr. Manduka was using the distinctive Hughes Healthcare logo lavishly. I think the final point that I draw your attention to is that paragraphs 128 and 129 of the judgment on the question of who Acon was willing to sell to. You saw the letter sent by Gardner Leader, who referred to Medco and Pharmaceuticals Direct. And then also in the bundle, there's a WhatsApp exchange between Mr. Manduka during the subsistence of the partnership and an employee of Acon, where Mr. Manduka is complaining about another distributor called Connect 2 Pharma. Then there was NFL. Then there was the partnership. So it's not right. I mean, at what point do you become selective? This wasn't like the House of Darts, which of course wasn't a partnership case, where the House of Darts was the exclusive retailer of the pentathlon dart. Oh, yes, sorry, yes. And also, it's not correct that duties cease to exist when another partner is in breach. Mullins and Loughton, which is at tab 33.
Sorry, do you want to? Sorry, what was the?
Sorry, yes.
You may have misspoken. I
So it's just
that last thing. I'm just trying to understand where you're about to go with this.
Yes, I think I'm just going to address you a bit more on.
This is 1E again.
1E, yes.
Yes.
I'm being reminded I didn't address you on that. So it's not correct that duties cease to exist when another partner is in breach. Yeah, automatically. So I just want to draw your attention to Mullins and Loughton, tab 33, paragraphs 130 and 131, where Miss Justice Neuberger refers to the implied term of good faith in a partnership agreement. And I already addressed you on what Lord Millett was talking about in Hurst and Brick, and it's also being talked about in Mullins and Loughton, which was whether you can dissolve a partnership on the basis of repudiating a breach. We're not saying that the partnership was dissolved for that purpose, but what we are saying is that there's nothing to prevent a partner repudiating his duty of good faith and the other partner accepting that repudiation and thereafter being discharged from any further duty. Now, of course, if there's a pre-existing entitlement to property, that would still have to be realised. But
the way you just put it there suggests it has to be an overt breach accepted by the, in this concept, innocent partner.
yeah.
And I didn't think that was your.
No, it's not, because
This is why I tried to slow you down a bit,
Yeah.
because I'm either you're misspeaking or I'm mishearing.
Yeah, no. In addition, I say that there can be a repudiatory breach that one can rely on later. One can rely on later as repudiating the partnership contract on the basis of something that one didn't know about at the time. There should be no reason why the the principle that applies.
That's your Boston Deep Sea Fishing.
Yes, exactly, and also complete care, which was applied in that case. So finally, on what happened at the trial and
Ground 6 and 7.
yes, that's right. If I can just take you to tab 12 of the agreed supplemental bundle, you've been shown that the judge came back, you know, on 2 or 3 occasions, asking us questions. If I can, I'll go back to the conspiracy in a minute, but if I can just take you to paragraph 6 of page 60. I cannot see anything in the defendant's written or oral submissions about their paragraph 6 knowing receipt claim specifically. We're making submissions on the dishonest assistance element of the defendant's claim. Ms. Hilliard occasionally used the phrase knowing assistance. I think that's partly because the claimants did as well. But I propose, therefore, to treat oral submissions on dishonest assistance as relating also to knowing receipt, unless the defendants wish to point me to aspects of the oral or written closings that I've overlooked. And our response was, yes, that's all right. Using the terminology knowing assistance, make submissions as to the receipt of benefits and tracing of those benefits into the hands of the recipients, which is consistent with knowing receipt. So we did set out our stall there. In relation to the conspiracy claim, the facts were all there. The difficulty that the judge seemed to have is found at paragraph 478, page 182 of the core bundle, where he says the defendant's closing submissions did not explain why the participants in the alleged conspiracy should be taken as having an intention to injure JH. And of course, I understand that intentions can sometimes be inferred from the nature of the actions. However, care is needed before making such an inference. And what we say about that is that the facts were all set out from which one could draw the inference. You know, the Freddie Manduka sending his father, the way in which the profit share was going to be worked out in December, the invoices created, and Mrs. Manduka being copied in with the attachment. Mrs. Manduka drawing up the invoices, which showed that it was an invoice for services, notwithstanding that the judge found that it was a share. The fact that the money was paid by Newfoundland and described as commission. I mean, the facts were all there on which the court could find that there had been an agreement and that activities was performed pursuant to the agreement. And the only possible inference was, that it was designed to harm Mr. Hughes as a means to an end, as a means to furthering their economic interests, because as far as the participants were concerned, it assisted them that Mr. Manduka was helping them with their business, was diverting opportunities to them, and was counselling them about how to deal with Mr. Hughes. So in my submission, the facts were there, and the judge, if he did have any difficulty, given, you know, we had from tab 7 through to tab 12, detailed requests for information and clarification by the judge. If he had any problem about what inferences we were inviting him to draw from the facts that were, which he found, then I do say he should have asked us. I mean, I accept that, you know, it was a long trial, there were so many issues, but it was unfair. Yes, my learned junior wants to explain something about your bundle. No more submissions. Thank you.
Ms. Rogers.
Thank you. Only to hopefully bring some clarity to the Radcliffe bundle. There was a Radcliffe Chambers folder bundle which had tabs 1 to 5. I did say I would update your bundle.
So we can
course.
amalgamate
Yes,
into one bundle.
precisely.
I follow.
And once you've amalgamated the two, that has tabs 6 to 12, that is everything from our side that was additional.
Where is the Churchill case?
That's at
I now have it.
12, yes.
Okay.
So tabs 1 to 5 were in the original bundle.
Right.
Tabs 6 to 9 were filed electronically with the note that was produced at the start of day 2.
I don't think I've got an electronic version of the 12 one. The one with 12 tabs, but I'm making.
Yes, that's right. We are for your ladyship. We are making an electronic bundle of all 12 tabs. 11 and 12 are new today. I've explained to my learned friend who's kindly said that he's happy with that. 11 is a extract from Blackett Ord on the points.
That's fine. That's fine.
Grateful. Thank you.
Ms. Mayor, I haven't worked out in my own mind whether you might be said to have a right to reply on new cases, in the sense that certain new authorities were referred to orally for the first time, but they were already in the bundle. I'm not encouraging you to exercise any right to reply that you might have on the limited materials that Ms. Hilliard introduced. Good. In which case, you will be surprised to know that we are not going to give judgment here and now. You will receive judgment electronically in the normal course for you to point out our errors of typing in English. That won't, of course, be an opportunity to re-argue points. We'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we would expect to settle the points in the order that we make. Finally, although I know this will be well known to everybody, I ought to remind you of the importance attached to the embargo. Breaches are still occurring, and that is a matter that is taken very seriously. But thank you all for your assistance.
Thank you.